May it please the Court. My name is Kate Cole, and I represent Plaintiff Appellant Building Graphics Incorporated, an architectural firm in Charlotte, North Carolina. Building Graphics appeals the District Court's order granting summary judgment in this matter to appellees who, according to Building Graphics allegations, have infringed Building Graphics copyright rights in 3 sets of architectural plans for homes. Building Graphics respectfully submits that the District Court committed reversible error in this case on 3 issues. The first relates to the issue of access. On this issue, the District Court invaded the province of the jury in its analysis of the evidence and improperly concluded that as a matter of law, there is no genuine issue of material fact as to whether appellees had legally sufficient access to Building Graphics plans. Second, in analyzing the issue of substantial similarity, the Court committed legal error by failing to apply the appropriate Fourth Circuit test for that issue. Instead, at the invitation of appellees, the District Court conducted an analysis based primarily on an 11th Circuit decision called the Intervest case. The Intervest decision is inconsistent with Fourth Circuit precedent. Indeed, as recently reaffirmed in this Court's very recent unpublished opinion in Charles W. Ross Builder versus Olson Fine Home Building, a decision issued from this Court about 2 months ago. In so doing, the Court analyzed this issue with a focus on differences in detail among the plans, a focus that is inconsistent with the appropriate test for substantial similarity. As our third point, and as we argue in our brief, when the appropriate test for substantial similarity is applied to the plans at issue in this case, and in viewing the evidence in the light most favorable to the non-movement at summary judgment, Building Graphics, the only outcome is that there is a triable issue of fact as to substantial similarity. We respectfully submit that this case should not have been dismissed at summary judgment. I'll first address the District Court's analysis of the issue regarding access. According to the law of the Fourth Circuit, in order to establish access in a copyright infringement case, Building Graphics was required to show evidence that appellees had an opportunity to view or copy Building Graphics plans, not evidence that they necessarily saw the plans.
I thought the test was reasonable opportunity or reasonable access. You didn't use that word in your formulation.
Well, yes, Your Honor. As I might continue, in the Towler v. Sales case, you're absolutely right. To demonstrate access, this Court there said it must be reasonably possible that the paths of the infringer and the infringed work crossed. That's how the Fourth Circuit has formulated it.
So having it on a website, which is available to everybody with access to the web, is not enough.
We would not submit that that is enough.
Okay.
In fact,
having it available in sales material by itself is not enough.
That alone, we would not argue is enough.
Okay. So what's the plus?
Yes, certainly. The plus here is viewing the layers of evidence as a whole, and I'll tell you about that evidence. As an initial matter, and as set forth in our briefs, appellees admit that their plans were copied from some pre-existing plan. Now, that's undisputed. Now, they have claimed that that pre-existing plan was a plan they owned called the Fairfax, but the evidence in this case clearly shows, and in fact the District Court agreed, that the plan they copied could not have been the Fairfax. Next, when you assess...
Can we stop there for a moment? Because I find that interesting. So you want to factor into your showing in support of your prima facie case of reasonable access the explanation, which I guess the record somewhat rebuts, offered by the defendant. And can you do that?
I believe we can, Your Honor.
Explain
Under this Court's Towler v. Sales case, which I believe was issued in 1996, the Court, when considering the defendant's denials regarding access, noted in that case, conversely, that there was no evidence in the record to call into question the defendant's credibility regarding their denials of access. Here, we would submit that given that they have offered and strenuously stuck to, if I might say, this claim that they created it based on the Fairfax, and that has been proven to be untrue, we believe that, pursuant to the Towler v. Sales case, it's proper to argue that that calls into question their credibility with regard to their denials of access. And I would say that we don't base our claim of access solely on that evidence alone. We think that's just the first step.
So your argument is that if you look at everything in one big pot, it shows that there was an access, and part of that analysis, I take it then, is how similar the buildings look?
There is certainly case law that supports the notion that when the plans at issue are strikingly similar, access can be inferred. In other words, they are so
You're
close.
not arguing striking similarity.
That's
here.
right, Your Honor. We are not arguing that in this case. And
The
to answer,
reason you didn't argue that in this case?
because we believe that the factual evidence regarding access is sufficient in this matter to support a finding of substantial similarity. I certainly am not conceding that the plans are that close, because we believe they are. But we believe the rest of the evidence of access, to use your words, Judge Gibney, that falls into the bucket actually is interrelated and shows a reasonable possibility that the paths of appellees cross with building graphics works. As we argue in our brief, there's significant evidence regarding the due diligence efforts of Lennar and its local predecessor in Charlotte, Don Galloway Homes. The evidence shows that both Lennar and Don Galloway engaged in due diligence prior to designing homes for our new neighborhood. In other words, they went out looking at the houses and plans of their competitors in the local architecture and local home builder fields.
And they say that the currently available, that's the defense position.
Certainly, Your Honor. I would note there's conflicting testimony on that point, which we submit supports the notion that this is a question for the jury. What further makes this due diligence evidence relevant is a review of the availability of building graphics plans in the very places Lennar or Don Galloway would have been looking. The evidence is undisputed that building graphics plans were designed by a well-known, prominent Charlotte architect, again, a local architect, for use by local home builders, at least one of which was a competitor of Lennar's local predecessor. Building graphics also showed that its plans were available on the internet through sales materials and actual homes constructed in the Charlotte market.
Well,
Again,
how many building plans are on the internet? There must be millions of them.
we don't dispute that, Your Honor. However,
And there are hardly any houses that you could find in Charlotte that followed Mr. Snodgrass's designs.
so let me respond to both of those points, if I might. With respect to availability on the internet, we are not arguing that these were merely availability to the world and that Lennar was looking at the entire body of the internet when it was searching for online plans. Instead, the building graphics plans that were available on the internet were through Building Graphics' local architectural affiliate, Living Concepts, a known Charlotte architectural website to go to. Lennar's 30B6 representative testified that in reviewing the plans of their local competitors, which was shown to include local architects, they often looked at plans online. In other words, we say the relationship is a little bit closer than simply saying mere availability on the World Wide Web. And our position again.
I think they looked. He didn't say that we look back 10 or 12 years to see what they were building then.
No, Your Honor. However, I'll note that the Lennar's designated representative was not employed by Lennar at the time. They weren't able to offer anyone who was. But I'll also note that the plans available on the internet were available from the dates of their creation, which was just a few years before the appellee's creation dates, through the present time. As we have submitted, we believe all this evidence viewed as a whole creates at least a genuine issue of material fact for the jury.
Ms. Cole, does the record show how many local architects or home builders there are in Charlotte and the metropolitan Mecklenburg County? I mean, it's a big area, so what are we talking about?
I don't dispute that, Your Honor, but that information is not in the record.
Not in the record.
However, the proprietor of Building Graphics has been in the architecture field for nearly 40 years, and as I said, is a well-known, award-winning Charlotte architect. If I might briefly address the issues of substantial similarity that are also part of our appeal in this matter. In this case, the district court departed from the established Fourth Circuit test for substantial similarity in copyright cases. Fourth Circuit law is clear that contrary to appellee's assertions, in analyzing substantial similarity, including at the summary judgment stage, the district court was required to engage in a specific two-pronged test. It is undisputed that the district court did not analyze both those prongs here. That analysis of both of those prongs of the two-part test is required in cases like this today, an architectural works case, is supported most recently in this court's opinion in Universal Furniture, as well as this court's very recent unpublished opinion in Charles W. Ross Builders, in which this court found legal error in the district court's failure to apply the Fourth Circuit two-pronged test. Instead, what the district court here did at the invitation of appellees was to engage in an analysis that is inconsistent with the Fourth Circuit test and was based in large part on the law of the 11th Circuit, the Intervest case I mentioned earlier. When you look at the district court's opinion, you can see that while the district court started its substantial similarity analysis referring to the test in terms that come from the intrinsic prong, which is the second part of the Fourth Circuit test, the district court did not proceed to conduct that analysis, either the first or the second prong. Instead, with reliance on case law from other circuits, the court concluded without analysis that building graphics architectural works are necessarily compilations and entitled only to thin protection as a matter of law, and went on to state that instead of being required to show substantial similarity, building graphics was required to show super substantial similarity in order to demonstrate infringement. Your Honors, we respectfully submit that it is not, nor can it be, the law of the Fourth Circuit that architectural plans are, as a matter of law, compilations entitled only to thin protection, requiring a substantial similarity analysis different than what this court has long followed, including recently in the Universal Furniture case and in the Charles W. Ross Builder case. Indeed, the court proceeded under the 11th Circuit precedent to conduct a substantial similarity analysis, if we can call it that, based not on similarities, but based almost exclusively on differences between the plan.
So your view is that under the extrinsic test, what the court should have done was list the similarities and the differences and sort of weigh them out?
No, Your Honor. Under the extrinsic test, the court, according to the Towler case and the Lyons case from 2001, I believe, was required to search the record, examine the record, searching for similarities on extrinsic issues. The case law actually doesn't even say anything about differences. Now, we're not arguing that differences are completely irrelevant here, but the focus is to be on similarities in idea. Courts say you should focus on things like themes and ideas. We have set forth, in fact, a very detailed list of some of the ideas embodied in our works, and we would argue that the selection, coordination, and arrangement of those ideas in our plans is what gives our works copyright protection.
Your more fundamental objection is really the failure to conduct the intrinsic prong of the analysis, isn't it?
Well, we would maintain that the district court did not even properly conduct the extrinsic prong, that instead the district court departed from Fourth Circuit precedent and instead relied on the Intervest case based on the notions that these are all mere compilations entitled to thin protection so that it could then only examine...
You're really saying that the court just went off the rails because it followed Intervest and didn't go with the universal furniture test?
Yes, Your Honor. The district court did not acknowledge or address the extensive similarities between the plans and elevations at issue, which are apparent from a review of them, but dismissed them with the notion that this can be attributed to the fact that the variety of ways a two-story rectangle can be divided into 3 bedrooms, 2 baths, a kitchen, etc., is finite. This view of architectural plans is not only inapplicable to home plans like those at issue here, but completely undermines the copyright protection afforded to creative works of architecture pursuant to Congress's Architectural Works Copyright Protection Act, and is unfair to architects and the artistry and creativity that is a part of their work. I see that I'm out of time. Thank you very much.
Thank you, Ms. Cole.
Thank you.
Mr. Stevens?
Please the court. My name is Eric Stevens. I represent Appellee Drafting and Design Incorporated. I'm here. I'm going to spend the first 10 minutes of the Appellee's arguments discussing the issue of access, and then Mr. Tom Wright will spend his 10 minutes with the court's pleasure discussing the issue of substantial similarity. So with respect to the issue of access, as Your Honor has noted, the standard is whether the plaintiff is able to produce affirmative evidence that establishes a reasonable possibility, not just speculation, not just conjecture, that the paths of the infringers, the alleged infringers, and the infringed work intersected in some manner.
Where does the word, I'm sorry, go ahead.
I think we're asking the same question. You go ahead.
Where's the word affirmative come from?
Well, they have to produce evidence, and they have to come up with some affirmative evidence as just a general statement of the standard for meeting a prima facie case on an issue on which the plaintiff has the burden of proof. That is my understanding of the general Rule 56 standard for getting to the jury on an issue on which the plaintiff has the burden of proof.
You don't think negative evidence in the form of impeaching the defendant's explanation could ever weigh in favor of the plaintiff's prima facie case on the issue of reasonable access?
I do believe that it could weigh in favor of the plaintiff on that issue if there is at first some affirmative presentation that at least gets the plaintiff close, Your Honor, if that makes any sense. And let me get to the details of this case to tell you what I'm discussing. The plaintiff's burden, according to this test, is again to place the infringed works somehow in the path of, in this case, the scouts for Lennar Homes or its predecessor in interest, who the record shows would, when they were moving into this new neighborhood in Charlotte, engage in a due diligence process before they would begin to build homes there. And the evidence is very clear that this due diligence process was constrained, and there were some very specific limitations on what these people were looking for and where they were looking. Specifically, they were looking at new homes that were being built by competitive builders in the market that they were entering, which was about 2001, which is when the appellees were working on these designs. And they were also looking for homes that were a similar cost and size to what Lennar was going to be building there. So in order to come within that circle, Your Honor, what the plaintiffs needed to do was to produce some evidence that a scout looking under those parameters would have come across a home built from one of these challenge designs, or would have come across marketing materials for a home built with one of these challenge designs in a neighborhood that fits within those parameters.
How long before the scouts went out, as you call them, did Mr. Snodgrass come up with the plans that are in question in this case?
There are three separate sets of plans. The first set of plans, the Chadwick, was designed in 1993 for a builder that went out of business and did not build any homes beginning in 1995. The second set of plans was designed, I believe, in 1997, and the third set of plans was designed in 1998. The evidence is that drafting and design began working on the challenge plans in 2001.
That would have been, was that before or after the talent scouts went out to see what was being built in the area?
Your Honor, there's really not a great deal of evidence regarding the timing of when the talent scouts would go out. I mean, what the testimony was about habitual practices, because there was nobody around who was able to testify specifically about where the talent scouts were going, who were scouting to put homes in the neighborhoods where these challenge homes were going to be put. There's no specific testimony about that. There's just testimony about what habitual practices were. And the habitual practice was, before you go into a new neighborhood, that's when you conduct your scouting.
So we're talking about a period of about 3 to 4 years.
For two of the designs.
For two of them.
Yes, and then for the other one, which is the floor plan design.
More like 7 or 8.
6 or 7 years. That's correct. And what we have, so that's the evidence of the circle, where the defendants were looking. What we have as far as what they might have found is merely with respect to the two elevation design plans, the Ballantrae and the Springfield. There's evidence, there's photographs of built versions of both of those homes in the record, but there's no information regarding where those homes are placed. So they could have been placed in Texas, they could have been placed, somewhere in Charlotte. What the plaintiff is trying to say is, well, you can presume that perhaps they were placed somewhere in Charlotte because they were built by a designer that was based in Charlotte, or by a builder that was based in Charlotte. But that's the only information that they have. With respect to the Chadwick, the information is even more sketchy than that. There's a dispute about whether there's any evidence that a home built from the Chadwick floor plan was ever built. But the court doesn't need to really resolve that dispute. It's the same issue. If a home was built, we don't know where. And there's no evidence that would point the court there. So in looking at whether the paths of Lennar's due diligence or its predecessor's due diligence and a built version of these homes or a cut sheet, marketing materials marketing these homes, you don't know where these homes are being marketed, so you don't know where the marketing materials would have been going. And so there's no evidence that would allow a jury to make a reasonable inference of access.
Well, didn't Mr. Snodgrass find at least 2 of these houses built in the Charlotte area?
No, Your Honor. Again, the only evidence is that there are photographs that were in building graphics files of built versions of the homes. But Mr. Snodgrass went looking for built versions because he thought that there was infringement when he saw the homes that the plaintiffs were building. He drove around all over Charlotte looking for them. According to his testimony, he couldn't find one.
Okay.
So what they want is for the court to infer that somehow the due diligence scouts for our clients found something that the plaintiff's representative who designed these plans was unable to find. With respect to the issue of the internet, the plaintiff, the way they try to bring Lennar close to their plans on the internet is they pointed specifically to testimony from Lennar's 36 representative that when they're doing the scouting process, they would look at competitor homes online. But that very testimony that they relied upon limited that hunt to homes being offered by competitive builders. And he specifically stated in his testimony that they did not look at websites of architects when they were conducting that kind of search. And so, again, that does not square the circle that you have to square in order to satisfy your burden. They also talk about John Gardner's testimony, and he talked about looking at architects' plans, but only plan books and not on the internet. So again, they fail to square the circle. The final point with respect to this independent creation argument is that how or if our clients came into possession of a third-party architect's plan, the Fairfax plan, has no bearing on this central issue, on whether the path of the infringed works, the Chadwick, the Ballantrae, the Springfield, came into the pathway of the people who were out there scouting before this new design was created by the defendants.
You're saying that wouldn't even be circumstantial evidence that could bear on the issue of access?
Well,
that would have to be your position, wouldn't it?
Whether or not it's a different plan, and so it doesn't make it more or less likely that our clients saw the plaintiff's plans. It's a completely different plan, and whether or not they had access to that and when has no bearing on that issue. The only way it could have bearing, again, is this credibility determination, and we've cited the court to the Tomasini case, where the court specifically said just attacking the credibility of the witness is not as sufficient to.
Well, what would it be relevant to? Are you saying it would be relevant to substantial similarity? It's got to be relevant to something. It
would be relevant to if they established a reasonable access, if they met their prima facie burden on reasonable access, then the defendants would have the opportunity to rebut that with evidence of independent creation. And the evidence about the Fairfax would enable the defendants to establish that defense. And what the district court held was that because there's this gap in that independent creation evidence, we would not be able to satisfy our burden at summary judgment to meet that defense.
You're saying it can negate already established access, but it can't stand on its own to establish access.
That's correct, Your Honor.
Do you agree that the issue of access pretty much boils down to that question? What weight we put on this negation? Because otherwise you've got the internet, you've got, some issues, some evidence, but...
I'm not sure I understand the question. Our belief is that they failed to satisfy their prima facie...
I think the plaintiff is suggesting that this negative evidence regarding independent creation puts it over the threshold that they need to get their issue into court, into trial.
Okay.
And do you agree that that's what separates this case? I mean, that's the definitive issue that we have to decide regarding access. What weight, if any, does the negating of independent creation, what weight is that given in the initial access determination? You're saying 0, and she's saying yes. And what I'm thinking, hearing the two of you, is that this is going to be a pretty big part of this court's determination whether access was established. And do you agree?
Certainly, the weight that you give to the independent creation evidence is important. But we do believe that if you compare this case to the other reported cases that deal with the sufficiency of access, evidence of access, that this case falls squarely within the factual realm of cases that have decided that summary judgment is appropriate. And I refer specifically to the Ale House case, to the Art Attacks case, and to the Toller versus Sales case that was cited there. The facts of this fall within that, and the Tomasini case also deals with this issue of the credibility of the denials, and the court granted summary judgment there as well.
Thank you, Mr. Stevens. Mr. Wright?
May it please the court, my name is Tom Wright, and I will be addressing the issues related to the trial court's determination that there is no substantial similarity between the plans at issue in this case. To begin with, in that regard, the trial court did nothing wrong. In fact, a reading of the record and the order indicates that both prongs of this circuit's two-prong substantial similarity test were conducted.
Where was there an intrinsic analysis conducted by the court?
Well, it says, I believe it was, well, the court refers to viewing the works as an ordinary observer in the joint appendix at 730. So the way it came down was they did the initial extrinsic analysis where dissection is appropriate. So the court, looking for the similarities that
how is this case, I realize that Charles Ross Builders is not binding precedent because it's not published, but how is this case analytically any different from Charles Ross Builders on the issue of substantial similarity?
I don't think that it differs a great deal in Charles Ross.
It's the same, isn't it?
I think so, because, and there the court, the issue with Intervest, which has been raised by the appellant in this case, in Charles Ross, Your Honor wrote, acknowledged the Intervest holding that architectural work could be viewed as compilations due to the fact that they are composed of largely pre-existing elements that are arranged in a different way. And in fact, in footnote 5, the last footnote, on remand in that case, the court directed the trial court to consider the thinness, which is the Intervest discussion of compilations, in performing this circuit's two-prong test. So, as I said, I think the emphasis on differences as opposed to similarities are really two sides of the same coin. If you do an analysis, if you compare two plans, you will either find similarities or differences. If you set out to find similarities but there are differences, that's what ultimately pertains. In this case, the trial court looked at a lot of things for similarities. In fact, they looked at the footprint, the square footage, the windows, the entries, the room placement, the fireplace placement, the size of the foyer and the hall, the roof lines, the materials used, and the trim, and found all of those to be different. The fact that they found them to be different doesn't mean that they didn't look for similarities, but you can't find similarities that don't exist. And in fact, this court
The
has...
most striking thing about the, not striking in the sense of striking similarity, but isn't one of the most unique things about the Springfield design that it has these sort of 4 layers of front that go back, and both the Springfield and your client's Hampton plan have almost identical shapes in the front.
Yes, Your Honor, but when you look at the plans themselves, you see that the footprint, while it looks that way subjectively, objectively, it is not substantially similar. And you're performing precisely the analysis that Building Graphics would hopes for, which is to jump the extrinsic analysis and ignore all of the facially obvious differences that exist to get to a much more subjective analysis and say, well, they look sort of similar. And that's the very purpose of the objective test, is to make sure that there is an objective basis for believing that there has been copying before you move to the much more subjective intrinsic analysis.
Well, but isn't certainly the stair stepping of the front facade of the house is it's like it's the signature of that design. Doesn't that count for a lot in terms of similarity? I mean, yeah, the doors are different, the windows have different mullions, but doesn't it count for a lot that it's...
Well, it may count for some, but it does not. I mean, there's no evidence in the record that, in fact, that particular feature is original to Building Graphics. In other words, as in treating these plans as compilations of pre-existing features, that sort of facade can be found in other plans. And so,
was there any evidence about that?
I don't believe there's any specific evidence about other plans with that footprint or with that outline, although the Fairfax plan is in the record, and it may not, well, the floor plan is. I'm not sure that the elevation is.
What about the coins? What about the coins?
Oh, the coins at the, well, again, these are small individual elements. And we're not saying that the plans themselves bear, that there's nothing in the plans that reminds one of the other. But those are all well-established, pre-existing architectural elements that you can find in any of the plans that are in the record. And I think
I looked at your website.
Excuse me?
I looked at your website. I couldn't find any other coins.
I can't, but, well, I don't think, and perhaps Ms. Cole will set me straight, I don't think Frank Snodgrass claims to have invented the coin, and with all due deference, sir, I'm pretty sure I can find a Lennar home that's got a coin or two in it. But, or on it. But I think this...
They cost a few coins, I'm sure of that.
But I think this is a good, this discussion of both the front aspect and the coins exemplifies the importance of the objective test, which is not to get bogged down in minutia.
Minutia? The front of the building? That's not minutia. I even noticed it.
Minutia, okay. Minutia may be too strong a word. Any individual aspect to establish copying, since the plans as a whole are what is protected, not simply the front. And that's why it's substantial similarity. It's not similarity of, a piece here and a piece there. That's why, as I said, this court has said that a list of similarities scattered throughout the plans is inherently subjective and unreliable. I believe that's Towler at 584. So, as I said, the list of differences is exhaustive, and the list of similarities much smaller. And at the end of the day, the trial court, I think, appropriately determined that based on the balance of those, that there is no indicia that one plan was copied to create the other, which is the bottom line here. Your Honors have no further questions?
Thank you very much.
Thanks.
Mr. Wright.
I might first respond briefly to some of the points raised regarding access in this case. Several of the arguments we heard from Council of Appellees, we would submit, certainly support the notion that there's a tribal question of fact here for the jury. For example, they want to point to testimony from Lennar's 30B6 representative that their review of home plans was limited to those of competitive builders online. At the same time, however, there is conflicting testimony from John Gardner, an individual who was employed by 3 of the home building entities at issue in this case at different times in his career, and has knowledge more consistent in time with the due diligence that went on here. And his testimony regarding review of architects was not precisely limited only to home plan books as referenced by appellees. My point here is that when we start to get down into the weeds on facts like this, it reiterates the point that there's a genuine issue of material fact here to be decided by a jury who's to make credibility determinations.
Well, isn't it all speculation? They could have driven around and found some of these houses. They could have stumbled onto the plans on the internet. They could have seen some brochures on it, but it's even all those things put together make it still a needle in a haystack to find this plan, don't they?
I understand your view, and that may be partially informed by many of the cases that the district court here relied on, and a lot of the cases regarding access that we see where the plaintiff merely asserts that its plans were available somewhere, and so surely the defendant must have stumbled upon them. Here, distinctly in this case, we have defendants, appellees, who were out looking for plans like these in the very places where building graphics plans would have been found. We think that this distinguishes the case here because, again, they were out looking for these types of plans, and there is undisputed, and in some senses perhaps conflicting, but again, that suggests a jury question, evidence regarding exactly where they were looking, many times in places where building graphics plans were in fact found. So the cases like Ale House and Art Attacks and those cited by appellees, again, are instances in which the defendant was perhaps copied some other work, perhaps created it in their head. There's no real evidence about how they created it, and the plaintiff's plan was merely available somewhere. There was no further evidence showing a reasonable possibility, not an actuality per se, but a reasonable possibility that the paths of the infringer and the infringed work crossed. And we submit that we certainly have enough here to, at a minimum, cross the summary judgment threshold, especially when viewing all facts in the light most favorable to building graphics. On that point, I would note that, as this court stated in the Campbell v. Hewitt case, on summary judgment, a court should not grant summary judgment unless the entire record shows a right to judgment with such clarity as to leave no room for controversy and establishes affirmatively that the adverse party cannot prevail under any circumstances. And we submit that the evidence here, when viewing that standard, again, as must be done in the light most favorable to the non-movement, shows that this matter should be tried to a jury.
At the same time, a jury's got to have sufficient evidence such that by a preponderance of the evidence, there was reasonable opportunity, correct?
Yes, Your Honor.
You don't dispute that. And so I'm struggling here. Why isn't this simply evidence in equipoise on the issue of reasonable access?
Well, for purposes of summary judgment, I would say that if we're coming to a question of drawing the line, then that necessarily implicates the role of a jury to view the testimony of witnesses like John Gardner and their 30B6 representative and the documentary evidence showing where these plans were available and where they went looking to determine.
But what did Gardner say that would justify a reasonable juror saying, he said that, that's enough for preponderance?
Absolutely. For example,
Can you give us a quote, perhaps?
Sure. Well, I can come close to quoting it, if I might, from my memory. The testimony of John Gardner established that UDC Homes, who is the home builder for whom plaintiff's Chadwick plan was designed, was a direct competitor of Don Galloway, Lennar's local predecessor. And it's undisputed that both Don Galloway and Lennar, during due diligence, looked at the home plans of their competitors. John Gardner also backed up the testimony regarding reviewing the plans of local architects. And there's lots of testimony in the record regarding the respect and renown, if you will, of Frank Snodgrass as an architect in the Charlotte market.
I'm sorry.
No, go ahead.
The problem I'm having with this argument is the Keeler Brass analysis. It seems to me that the Keeler Brass analysis is saying that negative evidence of independent creation may ultimately go to show that the design was copied, but that it doesn't go to the issue of access. It doesn't flat out say that. The case does not say that it doesn't go to the issue of access, but it does say that it has evidentiary weight for whether the design was copied.
So you're referring to the issue of Appellee's contention that they copied the Fairfax,
Right.
their pre-existing plan. I'm certainly not representing that Keeler stands for anything different than how you summarized it. We instead are referring to the factual notion that we believe a jury should be entitled to consider regarding the credibility of their denials regarding access in light of, frankly, the falsity of that story. And this court in Tyler v. Sales noted that on the issue of access, when considering the defendant's denial, the issue of whether there's any evidence calling into question the defendant's credibility is relevant on that point.
I guess what I'm thinking in my mind is you are really asking us to extend the law here a little bit, aren't you?
I believe that this is a reasonable interpretation of existing law based on these facts. I don't dispute that this set of facts that we have here is not precisely analogous to any that's been before this court before, but I don't believe that it would represent a change in the law. I think we're simply arguing that certainly these facts...
Expanding the evidentiary weight of negation of evidence of independent creation.
Well, simply given the fact that we believe the law is clear that this can be used to call into question their credibility, especially when we have an admission that they copied something else. In many cases, an alleged infringer created something in his home office, sort of shut off from the world, creating it out of his head. Here we have an admission that they created it with reliance on some pre-existing plan. Again, we believe that the totality of this evidence creates a tribal issue for the jury, and we respectfully request that the court reverse and remand on access and substantial similarity. Thank you.
Thank you very much. We'll come down and greet counsel and take a very brief recess before proceeding to the third case.